High Court has temporarily blocked President Uhuru Kenyatta from dissolving Parliament for failing to implement the 2/3 gender law. High Court Judge Weldon Korir, issuing conservatory orders, also directed the Chief Justice to appoint a 3-judge bench to interpret and harmonize Article 261 of the Constitution on the procedure for dissolution of Parliament. The ruling came barely hours after the Law Society of Kenya threatened to mobilize Kenyans to occupy Parliament on the 12th of October if the President failed to dissolve it. Kevin Washira with the details.
Parliament can temporarily breathe easy after the High Court blocked President Uhuru Kenyatta from implementing an advisory opinion by the Chief Justice to dissolve Parliament for failing to implement the 2/3 gender law. The High Court issued conservatory orders pending the determination of a petition filed by Leina Conchela and Mohsen Abdul Munsa on Wednesday. The duo queried the procedure of implementing Article 261(7) of the Constitution, which they argued was vague and did not outline the procedure for the dissolution of Parliament. In his ruling, Judge Weldon Korir pointed out the issues raised by the petitioners were weighty and required constitutional interpretation. He also directed the Chief Justice to appoint a 3-judge bench to hear the matter on the 7th October 2020. Parties in the case were also ordered to file their submission by Monday. Earlier, the Law Society of Kenya, through its chair Nelson Harvey, had threatened to occupy Parliament on 12th of October if the President failed to dissolve Parliament.
The urgency and finality is necessitated by an emerging and fast developing trend by certain individuals and institutions to belittle, berate, and castigate the Chief Justice for having advised the dissolution of Parliament as mandated by the Constitution of Kenya. Key amongst the individuals propagating the false, erroneous narrative is the Speaker of the National Assembly, Honorable Justin Muturi, who, unfortunately, is an advocate and ought to have handled the matter with wisdom and leadership.
LSK had written to the National Treasury to withhold MPs' salaries and asked the Ministry of Interior to withdraw police officers assigned to parliamentarians from 12th of October. Wiper Party leader Kalonzo Musyoka had also queried the pronouncement by the Chief Justice, which wasn't issued from the bench.
The fact that the learned Chief Justice did not deal with this matter in an open court where he could have been moved along with maybe 2 other judges of the Supreme Court and therefore be able to issue an advisory. My own position, even as an officer of the Supreme Court and the Court of Appeal and an officer of the High Court, being a senior counsel, is that advisory needs serious interrogation.
Kevin Washira, Channel 1 News.